Hello guys, welcome to my channel.
American children of undocumented immigrants and the American children of those here on visas, such as for work or study, are indeed persons born here in America. At the moment of their birth, they're subject to the laws of the United States with an undeniable constitutional claim to the rights, duties, and protections of that reciprocal relationship. In other words, citizenship. The 14th Amendment's guarantee that all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States, and that's the quote, clearly applies to those individuals. The plain text of that clause is about as straightforward a statement of American law as you can get. But there's additional support throughout the legislative history of this clause. In the debates on the passage of this amendment over a century ago, Congress clearly defined the intent and purpose of the Birthright Citizenship Clause and rejected the types of arguments being advanced against it today. Similarly, the Supreme Court considered and rejected arguments against the plain meaning of the amendment in the case of United States versus Wong Kim Ark way back in 1898. Subsequent cases have rejected the proposition being advanced by our colleagues today that the children of certain immigrants born in the United States should be denied citizenship because it's unconstitutional. Clearly, the law and history support the straightforward conclusion, and that's why 4 federal judges have already blocked the president's executive order attempting to end birthright citizenship. One of those judges, Judge Kuhnauer, a Reagan appointee, told Trump's DOJ lawyers the executive order was, quote, blatantly unconstitutional. In fact, he said in the courtroom, and I would hate to have been the lawyer on the receiving end of this, he had, quote, difficulty understanding how a member of the bar would state unequivocally that this is a constitutional order, end quote, noting that it boggled his mind. Flimsy arguments aside, ultimately, a president cannot unilaterally repeal a constitutional amendment. Any elementary student of civics knows the only way to repeal an amendment is with another amendment. Remember Prohibition? The 18th Amendment to the Constitution outlawed the sale and manufacture of alcohol in 1919, and it was repealed by the 21st Amendment in 1933. But there's the rub. Americans overwhelmingly support birthright citizenship. Presidents and extremists like Stephen Miller, who've championed the idea, know that they don't have the votes to pass a constitutional amendment to repeal birthright citizenship, much less get the approval of 3/4 of the states to make it law. So instead, they're trying to do an end run on the Constitution with a tortured and unconstitutional reading of the English language and more than a century of legal analysis. Our Republican colleagues are here today trying to enable the president as he pushes his wager that his Supreme Court, the one he stacked, will ratify his illegal attempt to amend the Constitution without the consent of the American people. As a Congress, as a government, as a nation, we should not be in the business of turning back the clock and allowing or pushing our country to backslide into the most shameful parts of its past. Instead, we should be passing laws that guide it toward the light of a brighter future, one in which our most fundamental American principles and the promise to form a more perfect union ring true for all, rather than just for a privileged few. I and my Democratic colleagues would rather use this committee to fight for. I yield back.
Good afternoon to members of the committee. I am especially pleased to be here to explore with you the meaning of 6 words of the Citizenship Clause of the 14th Amendment and subject to the jurisdiction thereof. The recurring debate over the meaning of these words boils down to a choice between 2 alternatives. Does it mean subject merely to the regulatory jurisdiction of the United States? That is, subject to the laws of the United States, as is virtually everyone on United States soil, including aliens who are here illegally, or are here for the purpose of bearing a child to make it an American citizen? Or does the jurisdiction of the United States mean something more than that? The full and complete jurisdiction, requiring an allegiance that comes from a permanent lawful commitment to make the United States one's home, the place where one permanently and lawfully resides. I believe that this latter interpretation is compelled by the Citizenship Clause's text structure, and history, as well as by common sense. I have time for just a couple of brief opening points. First, the text of the clause. If subject to the jurisdiction of the United States means nothing more than the duty of obedience to the laws of the United States, why did its framers choose such a strange way to say that? Why didn't they just say, subject to the laws of the United States? Doing so would have been quite natural, given that this straightforward, unambiguous phrase is used in both Article 3 and Article 6. The clause also ensures that birthright citizenship makes newborns citizens of both the United States and of the states wherein they reside. That is, where they live, their home. This word standing alone implies a lawful permanent residence, and it plainly excludes tourists and other lawful visitors, as well as illegal aliens who are prohibited by law from residing in a state, although they all must obey our laws. Second, the history of the clause. The clause was framed by the 39th Congress to constitutionalize the Civil Rights Act of 1866, which had been passed by that same Congress just 2 months earlier. The 1866 Act explicitly denied birthright citizenship to persons, quote, subject to any foreign power, close quote, and to, quote, Indians not taxed, close quote. It is clear from the debate in the 39th Congress that Congress decided to replace this language with subject to the jurisdiction thereof, not because Congress suddenly and without any comment decided to broaden the scope of birthright citizenship from the Act. Rather, Congress was concerned that the phrase Indians not taxed language generated uncertainty about the citizenship status of the children of Indians, primarily rich and poor Indians. The dispute is best captured, I think, by this comment from Senator Trumbull, who wanted to replace the words Indian not taxed, even though he was the principal author of the 1866 Act. He said this, I am not willing to make citizenship in this country depend on taxation. I am not willing, if the senator from Wisconsin is, that the rich Indian residing in New York shall be a citizen and the poor Indian residing in the state of New York shall not be a citizen. This comment reflects two important points about the intended meaning of the clause by its authors, I think. First, they intended that the children of tribal Indians who resided on reservations and owed their direct allegiance to their tribes would not be entitled to birthright citizenship, but the children of assimilated Indians who had left their reservations and had established permanent residence among the body politic of the states would be entitled to birthright citizenship.
President Trump issued an executive order to restrict birthright citizenship, but multiple lawsuits challenge it as unconstitutional. Federal courts have blocked the order, citing violations of the 14th Amendment, keeping birthright citizenship intact. Public opinion is divided, with most opposing challenges, and legal battles continue.